scope of writ under Article 226 of the Constitution of India has itself always been an intruding subject, and people have always loved to understand what is the scope of a writ. As they say, under this writ, you can claim anything under the sky, but it has its own parameters. And within these facets, another intruding facet is as to what is the scope of writ against the private parties. To understand this vital subject, we had requested Jamshed Pesi Cama, a senior advocate, Supreme Court of India, and he practices also on the Mumbai as well as Pan India. And he had readily agreed to share his knowledge and insights on this vital aspect. As we always say that on a weekend, we don't take much time on the introductions because people are always more keen to hear a speaker of immense knowledge like Mr. Cama. And thank you, sir, for accepting the invite on behalf of Beyond Law CLC. And we would like to tell the people that we had connected through Keshav Sharma, who had done one session with him. And we found that Mr. Cama had a wide knowledge. That helped when we requested Keshav to connect with him. Over to you, sir.
Thank you. Wide knowledge in law is limited. There is nobody who has too wide a knowledge. Law is a motion. Anyway, the topic today is law applicable to writs in the context of private respondents. You have to look in this context, in the first place, to the definition of Article 226. The definition prescribes that a writ or any order, writ, direction, or order against any person, including the state. The key point here is the words including the state. We as writ lawyers have, in the last 50 years, changed the concept of what is the government and what are the obligations of a respondent in case a writ is filed against that person. When the writ jurisdiction initially began, writs were accepted by the High Court only against the state, or essentially really state government and parties immensely close to that level of power. And nobody else was brought within the ambit of the state. But interestingly, the words that I mentioned just now, including the state, have gradually been gaining momentum, and people have begun to realize that a writ, by its very definition, Article 226, is not confined only to a state. Also, it is not confined only to the 5 prerogative writs that we have. It says any writ, direction, or order. Now, the words direction or order are yet not really gained much importance in the courts. Courts still tend to look only at the prerogative writs, mainly mandamus and certiorari. But it is something that I would like you all to consider in future whenever you are in practice, that you don't have to confine yourself to a writ. It can be even an order, which means that it is a highly inclusive definition and not an exclusive one. Coming now to the concept of against whom does the writ lie. As I mentioned earlier, we used to take the view earlier that it will lie only against the state. Now the question is, what is meant by the state? The state over a period of time has expanded. It first expanded in the context of a company and a cooperative society, if I'm not wrong, in the case of a statutory corporation. It went down the route that in the case of a statutory corporation, although it was not the state in the form of the government of the day, it was nevertheless an arm of the state. And it was considered that, as I said in those days, the long arm of the state. So the long arm of the state would impose its imprimatur even at that time upon a statutory corporation. So the concept of state expanded to a statutory corporation. Thereafter, the courts felt if you can have the long arm of the state in the context of a statutory corporation, then why not in the context of a cooperative society? So that was the law laid down thereafter. Then the question was, all right, suppose there's a company set up by the state. Then again, is that company not liable to a writ? Once again, is the long arm of the state not in that company when it comes out into the public? And once again, the courts held that a company set up by the state or a company which is like a PSU can and will be writable. There's a line of distinction which the courts have drawn. A company which is governed by its own articles and memorandum of association is, strictly speaking, a independent entity, independent of the government, so to speak. But nevertheless, it is writable under Article 12 and Article 226. Now, one has to also understand the concept of Article 32 and 226. Article 32 is only for enforcement of fundamental rights. Article 226 is not so limited. It is for fundamental rights and any other statutory, any other obligation of the state or an instrumentality or an agent of the state. Now the question will ultimately lead to whether such a writ can also lie against a pure and simple private company. I'll deal with that. But let's for a moment consider the evolution of the law. We can't go too much into that, but let us start with some of the more important judgments. In the case of Ajay Hasya versus Khalid Mujim, the court laid down that the only test is whether the institution is an instrumentality or an agent of the state. It is immaterial how it is created. Then we have what I consider a landmark judgment, and a judgment which really makes me as a lawyer very proud of our courts. That judgment is Andi Mukta Sadguru Trust versus Udani. Here, the court came to the conclusion that even at a private college, subject to public funding and close supervision by the university, would be writable. A writ would lie against a private institution like a college who is part of a university if there is public funding involved and close supervision. The courts held that in such a situation, the activity is not deprived of its public character. Subsequently, there are case law for the proposition that even without this public funding, running an educational institution is a public duty or it's in the public domain. Now, in Andi Mukti, the court further went on to say that English law is confined to authorities, as we understand them. That would mean a statutory authority. But there is no such limitation in this country. And at paragraph 19 of the judgment, the court considered what is meant by the word authority. And I can really do no better than to quote to you from paragraph 19. It says the term authority used in Article 226 in the context must receive a liberal meaning, unlike the term Article 12. Article 12 is relevant only for the purposes of enforcement of fundamental rights. Article 226 confers power on the High Courts to issue writs of enforcement of fundamental rights as well as non-fundamental rights. The words any person or authority used in Article 226, therefore, should not be confined only to statutory authorities and instrumentalities of the state. They may cover other persons or bodies performing a public duty. The form of the body concerned is not very much relevant. What is relevant is the nature of the body, the nature of the duty imposed on the body. The duty must be judged in the light of a positive obligation owed by a person or authority to the affected person. No matter by what means the duty is imposed. So therefore, the law now changed from saying that the respondent in a writ must be a state, an instrumentality, or an agent of the state, from saying that that is not enough. It will apply against any person, the word is used, any person who has a public duty or performs a public obligation. So therefore, this, according to the courts, would cover even individual companies or societies purely in the private domain, provided the nature of their work affects the public or a defined part of the prey. So when you talk of public duty, public obligation, what you're talking about is, does the entity you're dealing with have a public duty, like education, for example? Does it have a public obligation? For example, it would be like a company carrying on carrying on an activity like, for example, if there was a private company dealing in arms and ammunition manufacturing. Now, that would be a private organization, but its duty and obligation would be undoubtedly to the public. It would be performing a public function to that extent. It would then be writable. Now, the question arose that under what circumstances and by what means must that duty be imposed? And in para 21 of the same judgment, the court held that to be enforceable by mandamus, a public duty does not necessarily have to be one imposed by a statute. It may be sufficient for the duty to be imposed by charter, common law, custom, or even contract. We share this view. This is the view of the Judicial Commission. Judicial control over the fast expanding maze of bodies affecting the rights of people should not be put into watertight compartments. It should remain flexible to meet the requirements of variable circumstances. Mandamus is a very wide remedy which must be easily available to reach injustice wherever it is found. So now, the duty or obligation need not flow from a statute, need not flow from a government GR or a direction. It can flow, as I say here, from common law or custom or even a contract. Now you have contracts, for example, to construct civil contracts. If a civil contract has an effect on society where the contract is being executed, and if there is a breach of duty by the state, for example, or by the private contractor, for example, in the context of its obligations, then it is possible in certain circumstances to hold that that contractor, though a private party, though contracting with the state, is nevertheless liable to maintain his duty or obligation to the public, and that duty or obligation can be enforced by way of a writ. Subsequent judgments will demonstrate to you that a duty may be constitutional or it may be civil. The only difference is that in the case of a constitutional obligation, the remedy available is that of a writ. In the case of a purely civil obligation, the remedy available is civil jurisdiction. But the point is, and that's interesting, in one of the recent judgments of the court, they have said that there is a horizontality, that's the word you use. There's a horizontality between the rights in the public domain and the private domain. The reason behind this is that common law rights have been converted in certain circumstances to constitutional rights. Therefore, a party, for example, the right to freedom of speech was always there. The right against being assaulted was always there. But some of these rights have, through the Constitution, acquired a constitutional obligation. But the civil law right still remains. So where the person committing the offense is not the state, a civil remedy still lies. So there is a horizontal obligation, one by the state and the other by the private individual. Now, if the obligation confers, as I said, a public duty upon the party who is being writted, then that public duty is being enforced and you are not concerned with who the party is on whom that duty lies. Then we come to the next judgment I'd like to draw attention to is Pradeep Kumar Biswas. Here they said instrumentality or agent of the state includes a society or a company. So you will notice how the law has been expanding. First, it was society or establishment where the strong arm of the government was visible. Then it went on into Ande Mukti, very wide coverage, a much more inclusive coverage. Then here they have now prescribed that the words instrumentality or agent of the state would include a government company or a society. Now today in the economics of this country, the government is an equal industrial partner. It is in business for itself. Ultimately, of course, for us citizens, but it is in business in its own name. Now, a company set up by the government under the Companies Act with a memorandum and an article of association, such a company would still be writable. It may not be a company for some other purpose. For example, under the Industrial Disputes Act, you have the concept of appropriate government. So suppose a central government company operating under the Companies Act is set up initially by the capital provided by the central government. It would nevertheless have as the appropriate government the state government where it is operating. But it would simultaneously be liable to be written on the grounds that it is a government company. So therefore, the word instrumentality or agency of the government has now been expanded to include companies and cooperative societies. And indeed, I would go so far as to say any organization where the government has a hand. And as I will subsequently demonstrate, it will include even a purely private establishment which has a public duty. That's where we come to the next one. That is Zee Telefilms. In Zee Telefilms, BCCI, as who all of you know, is a private board, private establishment, was held to be liable to be written on the grounds that it is involved in selection and control of cricketers. And that is vital to the general public. So therefore, they said the establishment is entirely private, but it has its operations has a public effect. It affects the public in general. And therefore, the court held that it is liable to writs. Now, such a corporation may not be liable under Article 32. It may not have a fundamental right which it is invoking, but it will certainly be liable to a writ under Article 226 of the Constitution. The court held that a private body exercising a public function approved by the government has remedy under ordinary law and the Constitution. Now, here we come to that horizontality issue. If a private party has a public function or a public obligation, that party, to the extent of the public obligation, can be subject to a writ. Simultaneously, it can also independently be subject to a suit. So a private body is liable under both heads: constitutional obligation, if it is a public duty performing, and private party can also be subjected to a civil adjudication under civil law or common law. In Bini's case, Bini Limited versus Sadasivan, a question arose whether an employee could file a writ petition against a purely private company for the enforcement of his service conditions. The court held that no, a writ will lie against the private company under certain circumstances, but the nature of the relief which is being sought in such a case is in the realm of private rights. It is a private individual right of the individual employee which he is seeking to enforce by way of a writ. And the court said that there is no public element in that, and therefore a writ will not lie. Even against PSUs, there is some dispute or doubt as to whether a writ would lie. You see, if a public servant or an employee of a PSU goes to court, unless he can demonstrate that his rights flow from a statutory rule or a statutory regulation, unless he can demonstrate that, he cannot enforce a writ even against a PSU for the enforcement of his private rights. Now, very often people file writ petitions in the High Court challenging departmental inquiries, for example, or they challenge even breach of contract. In the case of departmental inquiries, normally a writ will lie because equally normally the rights of parties are governed by statutory regulations or statutory rules. So a writ will lie. But if a party seeks to enforce in the writ jurisdiction against a PSU a right which does not flow from a statutory rule or regulation, then in such a situation, the writ would not lie. So therefore, one has to look at the nature always. It is always the matter to be considered is the obligation. Is it an obligation in the public domain? If it is a purely private obligation, employer-employee, even a statutory employer and employee, purely in the private domain, it becomes a private dispute and therefore is not amenable to a writ. The only writ which really strictly lies directly against a private person, an individual, would be a habeas corpus. You can file a writ for habeas corpus against a private individual. I have my doubts whether you can file a writ against an individual for a private right. Interestingly, the question arises as to whether a writ will lie for breach of a statute against a purely private party. Now, in the Bombay High Court, I was a party to a petition that we have filed against a trade union because it had gone on an illegal strike contrary to the provisions of certain sections of the Industrial Disputes Act. The High Court upheld that petition and directed the parties to cease that strike. Now, here is an example of a purely private respondent engaged or whose activities are engaged in the public domain. A strike has an effect on the public. Therefore, an illegal strike was stayed by the High Court of Bombay. In Federal Bank, which is the only judgment of the kind I have seen in this case, the court held that breach of the Industrial Disputes Act can be writable. At the same time, it held that a bank is not writable per se, because although it is governed by the RBI, it is only a regulation. It is no obligation imposed by the RBI upon a private bank. So a private bank operating in the private sector is regulated by the RBI, but it is not controlled by, is not organized by, set up by, or controlled by the RBI in its normal operations. So please notice the distinction. A writ will lie to enforce a statutory obligation. I will assume that is because the statutory obligation, being part of a statute itself, is in the public domain. I must confess that the Federal Bank judgment is a very rare one. I have not come across any others. But I have been a party in filing a petition, as I mentioned earlier, in the Bombay High Court against a trade union for similar breach of statute. So it matters not who the respondent is. The only thing it matters is there a public duty or a public obligation which such respondent has to fulfill and which you want to enforce by way of a writ? Even in the realm of contracts, in ABL International, the Supreme Court held that every contract with the government involves an element of public duty. Supreme Court, being Supreme Court, has gone both ways. They have said in certain circumstances that in the pure contract, the state appears not as the state, a state company or corporation, for example. In the realm of pure commercial transactions, the court held that the state appears not as a state, it appears as a pure contracting party, and therefore a breach of contract would not entail a petition. On the other hand, as I mentioned earlier, in ABL International, the court held that every contract where the state is a party is bound to have a public law element, and therefore a writ would undoubtedly lie. It goes both ways. Now we come to the judgment in Ramesh Aluwalia, where the court laid down that Ajay Hasia's test. Now, Ajay Hasia laid down a series of tests as to under what circumstances a party can be held to be liable to writ. And they said that those tests are not rigid. If you fall under any one of them also, it's enough. The limited question is whether financially, functionally, and administratively, the respondent is dominated by the government. Here also they said that mere regulation is not enough. Even a purely private, uncontrolled institution is writable if it performs a public function. Therefore, in this case, providing education to children was held to be in the public domain and liable to a writ. We also got a subsequent judgment in BCCI versus Cricket Association of Bihar, where for the first time they laid down what is meant by public policy. Now, we are concerned with two things, public function and public policy. In BCCI's case, the court defined for us what is meant by a public policy. And they said, to quote, public policy is not a static concept. It is the fundamental point of policy of law, principle of law, and ensures justice, fair play, and transparency, objectivity, and promotes probity in discharge of public functions. And while that is opposed to, and anything that is opposed to these principles is opposed to public policy. In other words, any action which flows or could conceivably be governed by what we call the principles of law, and which seeks to, or which has the obligation to ensure justice, fair play, and transparency. Any such organization which has such a duty is operating in the public domain, and to that extent, a writ will lie. Subsequently, in a subsequent judgment, the court also defined what is meant by a public function. And they said that a public function is any function which involves discharging of a public duty. So therefore, a writ will lie. Remember Andi Mukti, they said we don't care how the organization came into existence. We don't care who set up the organization. We are not concerned with its content. We are only concerned with its obligation. So if I have any message to pass on to you today in the realm of writs in private sector, the answer, the suggestion I would make is always bear in mind only one thing: obligation, duty. Is it in the public domain? Is it in the nature of a public duty? If it is, writ will lie. It matters not who the respondent in your case is. There is a more recent judgment in this year itself in the case of Kaushal Kishore versus State of UP. Now, here, the court for the first time went into some detail in defining where a writ will lie against a private party. And it's interesting, really, to read this judgment because it gives you chapter and verse of the circumstances and situations in which a writ would lie. I'm not going to quote from it because there are several paragraphs dealing with this. And I would advise anybody who is interested in this issue to consider that judgment. I'll give you the citation is 2023 SCC Online, page 6. And I would like to now conclude this issue, I hope I'm not too fast, by referring to the most recent judgment of the Apex Court in the case of Kaushal Kishore versus State of Uttar Pradesh. This is what the court held in the context of private parties. A public duty or a public function entitles a writ to be filed. Public function referred to is a conduct which is similar to that being done by the sovereign in its sovereign functions. A statement by a minister, this is interesting. I don't know how many of you have even contemplated this. The question is whether a statement made by a minister on the floor of parliament could be the subject matter of a writ. The court concluded that where a minister makes a statement in his purely private capacity, even though he is in parliament, there's no writ involved. But if it can be demonstrated that he is speaking on behalf of the government, then there is a vicarious liability against the government. And that party and that minister, his speech could be subject matter of writs. Now, writs are essentially two kinds. One is negative, don't do this. One is positive, do what you're supposed to do. So, even against a private party having a public function, the court can conceivably turn around and say, stop doing what you're doing. You're doing wrong, you're doing something which is against public interest, public policy. Conversely, if the state is not doing something that it is obliged to do, then the court can issue an affirmative direction saying, do what you're supposed to do. At the end of all this thing, I again reiterate that a writ will lie in today's times against a private party. I must confess that it will take a little bit of judgment law to convince the high courts today about this. We are still in the high court level, and since judges of the Supreme Court go from the high court, there is still an element of doubt or reservation, if I may say so, for the maintainability of a writ against a private party. But in my opinion, there is no doubt about it. We have come to a stage in our constitutional evolution in the courts where a writ will lie no matter who the party is, if there is a public duty or if there is a public obligation. And the words public duty and public obligation have been given the widest possible connotation. So therefore, please remember, a writ will lie. Okay?
Thank you, sir. We can also chip in Z telecoms also. It also says...
I mentioned Z.
Oh, perchance I would have missed it. Because that was also an interesting aspect.
Z is because the Board of Control controls the appointment of cricketers, controls their rights, obligations, what they do, when they do, what they can do in the IPL, for example, a cricketer may be prevented by the board from playing in a foreign organization similar to the IPL. They may, and they do sometimes. They may prevent them from appearing in a set of matches which the board does not approve of. So the board has a control, and to the extent that the control affects a cricketer who is operating in the public domain, to that extent, they said in Z Telefilm, it will lie, a writ will lie.
So for people, what are the certain broad guidelines what were laid down in Ajay Hasia, if we can just brush across?
Yes.
Because Ajay Hasia is an important aspect.
Ajay Hasia is like 1981 Supreme Court. So you're going back about 30 years. And subsequently, as I mentioned, the courts have held that it is not rigid. You don't have to comply with every one of these tests in order to come within the domain of a writ. Even one of these is enough. And now they say, forget all that. You just look only at one thing, obligation. Is the respondent in your petition an organization which is liable to perform a public duty? Is it operating in the public domain? If it is, then it is writable. Anyway, since you want me to touch on Ajay Hasia, this is what Ajay Hasia says. It is immaterial with authority before it is a state. The only test is instrumentality or agency of a state. So you have to be an instrumentality or agent of the state under Ajay Hasia in order to be liable to a writ. Manner of creation of the body is irrelevant. The question is, why does it come into existence? However the body might be created, is it an instrumentality or agency of the state? Always the court in that case asks, is it an instrumentality or agency of the state? Again, they said instrumentality of the state is not limited to corporations created under a statute. Memorandum or articles of a society are instrumentalities of the state in a given circumstance. Composition of society, composition of society may be domestic or government, provided the government controls or has some control over it. There are a number of other tests. So please remember, this is old law. This is, as the courts have held, this is only an example. And if you fall under any one or more of these, you will be entitled to a writ. But you can ignore Ajay Hasia completely if you want to. In the case of a private party, because Ajay Hasia doesn't consider a private party. And today we are discussing the right to file a writ against a private party.
What about when we speak of Article 221, which says 226(1) of the Indian Constitution lays down that every High Court shall have powers to issue orders or writs, including habeas corpus, mandamus, prohibition, quo warranto, and certiorari, to any person or any government for the enforcement of fundamental rights or for any other purpose. So how will we come out within any other person or for other purpose? How do you elaborate that?
When I began, I started off by saying that the Constitution, that Article 226 is much wider than Article 32. 32 is confined only to fundamental rights. Under 226, you can go for any right, including a statutory right. And even if it's not a statutory right, you can go for the purpose of enforcement of public duty. You are not constrained by the respondent being a state. Any person who has an obligation which is of a public nature, which affects the public, is liable to a writ. And in Andi Mukti, they said that the law on mandamus has expanded tremendously. So today, what began with Ajay Hasia has ended in 2023 by saying that it can be lie against anybody. And one more thing I forgot to mention, in the last mentioned judgment, they've said that a writ will lie even on tort. Now, all of you are lawyers, you know what a tort is, civil wrong.
Talking about Kaushal Kishore Shukla?
Sorry? Yeah, last one.
Kaushal Kishore.
Kaushal Kishore, yes. They say a writ will lie against the government even on tort. So therefore, if a government commits a tortious action, for example, if a government, in one case, the Chief Justice had occasion to consider a man who had been wrongly imprisoned for 14 years. It was considered to be a tortious action by the state and a compensation was granted. In torts, the only relief is compensation. But it can be enforced by way of a writ. Nowadays, you find very often courts say, okay, don't do this, pay. Don't do that, compensate. So what we already knew earlier, that we were doing it for the first time, has received the direct seal of the apex court. Constitutional tort is a kind of right, and it is an obligation on the state and can be enforced by writ. Okay?
Thank you, sir. Thank you for sharing your knowledge. And it was quite a topic wherein we have learned a lot. And so tomorrow we will have session on the aspects of limitation under the CRPC by Mr. M. Karunanidhi, who is a member of the Law Commission of India. Do stay connected with us tomorrow at 6 p.m. And thank you, Mr. Jamshed Pesi Cama, for sharing your knowledge. Thank you.
You're most welcome. Bye-bye.